Supreme Court announced today that it will weigh in on a free speech case involving social media. The case involves a man who served a prison sentence for posting threats directed at his estranged wife and others on Facebook. His attorney argues that his client never intended to act on those threats. What the justices have to decide is whether that matters, as long as a quote-unquote reasonable person would feel threatened. Eric Subin is a trial attorney with experience in free speech and First Amendment issues, and he joins us here in our New York studios to parse this out a bit for us. Hi, it's nice to meet you.
Pleasure's mine.
Thanks for coming in. And so I just said in this introduction that the matter here is for the justice to decide whether or not intent matters. Is that the crux of this case?
It's not so much whether or not intent matters, but whether or not the law used to convict the defendant in this case is constitutional. The law that was used in this case says that intent does not matter, and that if you make a statement, whatever it is, if a reasonable person would feel threatened by that statement, then you're guilty, and that you can go to jail. And I think the defendant in this case spent 44 months in jail as a result of statements he made directed towards his ex-wife, his former co-workers, about shooting up schools. I mean, heinous and hideous statements, but he made them on social media. They were somewhat lyrical, at least that's what his argument was, and he said he never intended to do any harm.
So let me ask you this question. If he had gone and stood out on a street corner or gone to his ex-wife's place of employment and said these words in front of a bunch of people, would it be viewed differently by the law? Yes,
absolutely it would, especially if he went to his wife's place of business and started spewing sort of the hate speech that he was stating on his Facebook page. It would be completely different, because it's tantamount at that point to going into a crowded movie theater and yelling fire. I mean, just because there is freedom of speech, it's virtual protection for anything you want to say. It's not complete and absolute protection. You walk into a crowded movie theater and yell fire, then there is evidence at that point of an intent to do harm, of an intent to worry and cause fear. And people are going to jump out of windows and run for their lives. And at that point, there is reason to be threatened.
And I imagine that was what the lower court made the ruling based on, that this was a situation similar to that. Then the defense's argument that intent matters here, how can they make the case if he were to say this in a public setting, and even though it's electronic, social media is a public setting, what's the difference?
Because there was no immediate danger to the person or people he was threatening. The case that the defense keeps citing through each court they've gone up until the point that they get to the U.S. Supreme Court is this case of Virginia v. Black, which is a United States Supreme Court case from 2003, which states it was a cross-burning case, and the Supreme Court said that it's not prima facie unconstitutional to burn a cross unless there is evidence offered by the prosecution to show that there was an intent to cause intimidation, an intent to proffer threats. The mere act in and of itself is not necessarily a crime, because there is freedom of speech.
Yeah, but it seems so difficult. I don't know how the law can determine whether or not there's intent there. So I guess let me just ask you this. What's the trend of these types of cases? Because the truth is that our laws were written before social media was conceived. And so in some ways, our legal system hasn't caught up to the technology in which we live our lives. So in this case, how many of these do you see sort of coming down the pipe? Because I would think that these are going to become fast and furiously as time goes on.
Yeah, I would agree with that. Probably that is the trend, is to sort of stifle speech to a certain extent as it's put out there through social media. Because historically, it was the media itself that sort of had a monopoly over what could be publicly disseminated. And now anybody with a computer and an internet connection can put whatever they want essentially onto the internet for anybody to see. So it's going to have to be tapered down to a certain extent, but probably in this case, putting the man in jail for 44 months might have been a bit over the top, where there's other alternative remedies. The woman, the ex-wife, could have gotten a protective order, could have gotten a restraining order, and then if he violated that, there is the evidence that the prosecution needs to show intent. And then you can put him in jail for the years that he was put in jail for.
Mm-hmm. So is there a line right now with the law as we understand it that someone can cross using social media?
Right now, there is no bright line, clear-cut rule. That's probably why the Supreme Court granted cert in this case, in order to hear it and parse it out and to provide some clarification for the lower courts. Because right now, The defense has got a fine legal standing in Virginia v. Black to put forth their case in their defense to say that it was the law itself was unconstitutional and it has to be changed to require the prosecution to show some evidence of intent if they want a conviction.
Really so fascinating. I imagine this is a big subject of discussion in law schools all over the country.
I'd imagine so.
Yeah. Eric Subin, thank you very much.
Thank you very much for having me.
And you're watching Arise America.